Good morning.
All right, welcome back to the courtroom, and we are kicking things off with classic docket chaos. Look at Judge Simpson. He's trying to figure out who's who, and we've got a gentleman in a blue uniform who apparently doesn't know how to unmute himself. But notice this, Judge Simpson is personally identifying each defendant. That's not just being nice, that's establishing personal jurisdiction and making sure there's no mistaken identity down the line. He's already creating a record that's going to be airtight.
Everyone, the gentleman signed in from, not actually sure where you're signing from this morning, sir. You've got a blue uniform on, you're with the phone in front of you. I can't hear you just, but can you shake your head yes or no if you are Sir Huska? No. Okay, are you Mr. Jones? Perfect, thank you, sir.
All the things considering. All right. Courtroom County, Washington, State of Michigan, this hour of person. Oh, I don't have a bid for the court trial here. You may be seated. And of course, we just got to get situated. Just you can adjust the chair. Your legs are already on the ground. What are you doing? What? Yeah. I don't know. My chair is perfect for me. Miss Wildling? Miss Wildling?
Yes, sure.
We need a chair issue.
The chair doesn't go down.
Height wise. Her legs are only like this big.
Oh my God, they really aren't touching the ground.
Anyway, now that we've got that straight, Mr. Cook.
Morning, Your Honor. Brandon Cook for the people. Your Honor, the people would waive any potential conflict between this honorable court and the office of the public defender. While the people do not believe that any such conflict exists, we make this waiver in the avoidance of all doubt.
And who?
Morning, Judge. Torshio Feaster for Assistant Public Defender. We likewise do not believe that any waivers exist, any conflicts exist in this matter, but should any conflict arise, we will waive said conflict and ask this court to please hear those matters.
What? Big opening. That's a.
That's all.
Saw this big bald head coming toward me. You didn't even flinch. The court, for its part, also does not believe there's a conflict either in admission from court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consider. Court does call the cases. Will versus Chad Jones.
Edward Drugas on behalf of Chad Jones in 2196.
Stephanie Cannon,
Really?
Yes, Your Honor. On behalf of Mr. Jones, as to all other matters, you only have 2196, right? And Your Honor, I reached out to the facility. Oh, you got it?
I had reached out. We can set up a conversation with him. I was waiting to obtain discovery.
Jones, can you state your name, please?
Chad Jones.
Thank you.
So we should be able to coordinate with him. If we could have an adjournment to go over discovery.
So you got to get to him.
We've got to get to him.
So.
Attempts were made. I think the holiday weekend postponed things a bit.
23rd, the 28th.
Either one works, Your Honor.
Cause conference will adjourn then to July 28th. That's a Tuesday. 2026, 9 a.m. Bond will continue.
Thank you.
Thank you, Your Honor.
Thank you.
You know, so.
All right, thank you, Mr. Jones. Court calls the case, People versus Tracy Welsh.
Your Honor, Raymond Cook for the people.
Thank you, Your Honor. Alex Warren Green on behalf of Welsh. Ms. Welsh, could you please state your name?
Tracy Welsh.
And what are we doing?
Your Honor, I believe after the last appearance, our office submitted a plea form along with a police report. I have an advice of rights with me right now. The court in receipt of those documents.
What am I supposed to be in receipt of? I have a police report. I do not have any of the accompanying documents.
Okay, Your Honor, I have a plea form. Would the court consider a no contest plea today, or would the court prefer we adjourn this?
Well, usually I don't review the police report until I see the plea form. So know what I'm looking for. We're off to a good start.
Your Honor, can I provide the court with that plea form?
Apparently, you didn't hear what I just said, but that's okay. She's at.
She's not.
Yeah. I don't have an advice of right side.
Your Honor, I do have one in my possession. I just asked Ms. Welsh if I have permission to sign on her behalf as we discussed, Ms. Welsh.
Yes.
Okay. Your Honor, I'm happy to come back in a week on this and make sure that the documents are all in order.
That would be good.
Okay.
That makes my life easy. Everybody's life easier.
Your Honor, I'd ask.
Well, I have to go 2 weeks out. Is she gonna still be in Livingston County?
Her release date is July 15th, Your Honor.
July 15th? Then I'll tell you what, if she's getting released on the 15th, I'll just set this for the 16th.
Okay.
Well, if she gets out on the 15th, I'll set it for the 16th. If she's out, she can appear however she's going to appear.
Okay. Thank you, Your Honor.
You're
Thank
gonna
you.
need. So I'll adjourn this to July 16th, 2026 at 9 a.m. Bond will continue.
Thank you.
Yeah, thank you, ma'am.
Thank you, Your Honor.
Court calls the case, People versus Tyler Cochran.
How does that know?
Good morning.
Good morning, Your Honor. William Amadeo, P7619, formerly of Mr. Cochran, who should be coming in from the Washington jail. Tyler, please state your name for the court.
Tyler Cochran.
At this time, defense is going to waive their prelim if there's no objection from the defense. I'm working on a global resolution. I should say resolution circuit court.
So you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived. Defendant is bound over to circuit court on counts 1 through 5 with 6 following. Mr. Amadeo.
Your Honor, will waive a formal reading, stand mute, and ask for a pretrial date.
Defendant having waived formal reading, standing mute as to all charges. Court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Simpson.
July 28th, 2026, 1:30.
Thank you, Judge.
Bond continued.
Oh, Robert, we have versus information.
Yes. I don't know where Alan is. Oh, there he is. He's arrived. No, it's okay. Court does call the case. People versus Cameron Hall.
Current and those from people, Your Honor. In Zoom.
Sherilyn Foster Tucker on behalf of Cameron Hall. Mr. Hall, can you state your name?
Cameron Hall.
Got it. All right, I got it.
And Your Honor, we're requesting a preliminary exam in this matter, and if I may address bond briefly.
Discovery is complete.
To my knowledge,
What? Go. Aisha. Got it. What date are we on? People, this is available the 21st. Preliminary examination in person, July 21st, 2026, 9 a.m. before Judge Barr. As the bond.
Your Honor, I believe Mr. Hall's current bond in this case is 5,000 cash surety. He does have a case pending in front of Judge Barr, which should be resolved today. I believe he will be asking for a reinstatement of his bond in that case. His bond is currently denied in that case, is my understanding. He's just asking if the court would consider
What kind of charge is he before Judge Barr
on?
So,
Stalking, Your Honor.
it's a stalking charge.
In front of Judge Barr, yes.
And my understanding is he's set for trial today.
Yes.
Right.
Yes.
Okay. All right, response.
It's, the Barr case is a domestic stalking daughter for effective.
Oh,
He's
probably should have led with that, but go ahead.
asking for the court to consider either a 10% or nominal bond in case that case is resolved and he has a bond today.
At this point, I'm going to deny your motion. Changes bond will continue. Thank you.
Thank you, Your Honor. Mr. Hall, I'll come see you.
Okay.
Court calls the case, People versus Tegan Donnell. Donnell.
Morning, Your Honor. Raven Cook for the people.
Assistant Public Defender Zach Vinue with and on behalf of Mr. Nell, who's present via Zoom. Mr. Nell, can you please state your name for the record?
Tegan Donnell.
Your Honor, we're filing for competency in this matter. We would request an adjournment for that purpose.
Pardon?
We're filing for competency in this matter. You should have the form. We would request an adjournment for that purpose.
Forensic evaluation will be ordered. Competency hearing in this matter will be set for
October 8th.
October 8th, 2026, 9 a.m.
If I may
Bond
speak. I apologize for interrupting.
I'm sorry.
If I said I'm not meaning to interrupt you, but if I may speak on a matter.
Mr. Nell, you do have a right to speak. I would advise you not to, but that is your right.
But when he's done, I need to speak because we discussed the legal matter and you're ignoring me completely. So I guess I have to represent myself.
You want to represent yourself?
I guess so, because he's literally declining to step forward on something that's completely blatant in the case that makes it non-valid. The 14-day rule is a literal law that you cannot, if you're not arraigned or done such and such in the matter on any case within 14 days, you cannot arraign the case at all whatsoever. It has been almost 90 days. And you've not done anything in this case whatsoever. And he tried to make me think I did for some reason.
It's been 90 days since when, man?
No arraignment.
Your Honor, may we approach?
Pardon?
Your Honor, may we approach? I may be able to.
May. All right, record should reflect we've had a bench conference in this case. Mr. Nell, what I'm going to indicate is I'm going to leave this set for a competency evaluation. If you believe that a right of yours somehow been impinged, I'd suggest that you get to your attorney. And if they wish to file a motion or believes that it's appropriate legally or otherwise to file a motion, then they can file a motion before the court and I'll hear it. All right. Thank you.
I don't have a lawyer, but this case is almost over. This actual case is almost over. That being said, I You have not done anything within 90 days. You can't just randomly do or take legal action,
Ma'am,
70 days later.
ma'am, I
Yes, sir.
realize you're trying to tell me with your law degree what I should do. I just told you what I will do. That is how we're going to
Okay,
handle
to
it.
repeat-
You do have an
to repeat
attorney
what you were
representing
doing.
you in this case. All right, thank you.
I said, could you repeat what you're doing? So release to treatment?
No. Somebody's going to come down and they're going to talk to you and evaluate you, okay? And then we
Okay.
can decide where to go from there.
All right.
Okay, thank you.
Thank you, Your Honor.
I would say the same, but not. Court calls the case, People versus Xavier Butner.
Morning, Your Honor. Revoked for the people.
Should be Mr. Amadeus. Oh, it's Mr. Amadeus.
Where is he? He was all up in here.
Morning, Your Honor. William Amadeo, 76194. We have a Xavier Bonner. Xavier, please state.
Honor.
Judge, I just got an accurate phone number from Mr. Bonner. I took over the case about a week ago. I'd asked for a 2-week adjournment. Communicate with him. I do believe there might be discovery coming from Prosecutor Cook.
Without objection, July 23rd, 2026, 9 a.m. Bond continues.
Thank you, Judge.
Court calls the case of the People versus Sky, Freeman Jones.
Morning, Your Honor. Revoked for the people.
Good morning, Your Honor. J. Grant Miller, P58658. We're going to request a chambers conference, Your Honor.
Chambers conference?
Yes, Your Honor.
Want me to stop in the middle of everything right now?
I apologize. I hadn't spoken to Ann this morning, but I had indicated it to the other clerk. I didn't expect to be called. I apologize, Your Honor.
I'm not gonna have everybody wait while I do that. We'll take her back if you think that's necessary. I don't.
Your Honor, we're just
right now.
Your Honor, we're going to ask for a referral for competency.
Do I have an order?
I have not prepared one, Your Honor. I've been working all morning.
Forensic evaluation is ordered. Competency hearing will be set October 8th, 2026, 9 a.m. Bond continue. Thank you. Court calls the case People versus Eric Butner.
The people, Your Honor.
Okay.
Why does he keep leaving? Just chaining the Goldstein.
Morning, Your Honor. William Amadeo, 76194 for Mr. Buckner. Eric, please state your name. Your Honor, we'll be waiving the prelim on this, working on a global resolution in the circuit court.
So you're waiving your right to a preliminary examination? Yes. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit court on counts 1 through 3 with 4 following.
We'll waive a formal reading, stand muteness for a pretrial date.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea to all charges. Pretrial in this matter will be set for
September 1:30, Judge Hunky.
September 1st, 2026, 1:30.
Thank you, Judge.
Thank you.
I'll be in touch.
May I approach the side of it?
No. No. Give it to you. Court calls the case People versus Jesse Hardman.
Read it over for the Terren.
Morning, Your Honor. Edward Drupes on behalf of Jesse Hardman. This is a waiver, Your Honor.
Jesse Andrew Hardman.
You're waiving your right to a preliminary examination.
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed, the offenses alleged that were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Sir.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 7 with 8 following.
Your Honor, roll acknowledge receipt of the waive reading.
Defendant having waived formal reading, standing mute to all charges. Court will enter not guilty plea. Pretrial will be set for
July 20th at 1:30 with judgment.
July 20th, 2026, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Bond continued. Thank you. She's getting on my nerves. Court calls the case, People versus Terrence Hall.
Good morning, Your Honor. William Amadeo, P7619, on behalf of Mr. Hall. Terrence, please state your name for the court.
Terrence Hall.
Your Honor, this time asking for a 2-week adjournment. I was put on this case about a week. I want to make sure I have all discovery and we'll decide which way we're going to go if that's acceptable to the court.
No objection, July 23rd, 2026, 9 a.m. Bond continued.
Thank you.
Court calls the case of the People versus Justin Heaton.
Ready to go.
Robert on behalf of Mr. Heaton.
Justin, please state your name for the record.
Justin Heaton.
Thank you.
Your Honor, may we approach?
Yes. Record should reflect we've had a bench conference case. Requesting an adjournment of this matter. I'll grant that adjournment. Without objection. I'll adjourn probable cause to July 28th. 2026, 9 a.m. That's a Tuesday.
Okay, understood. Thank you, Judge.
Bond continued.
Thank you.
Thank you. Court calls the case of the People versus Christina Aker.
Morning, Your Honor.
Good morning, Your Honor. Marcia Creature on behalf of Ms. Aker.
Ms. Aker, can you state your name, please?
Christina Aker.
Thank you. He's waiving.
Yes, Your Honor.
Ma'am, you're waiving your right to a preliminary examination? Is that correct?
Yes, Your Honor. Yes, Your
You
Honor.
understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count. Ms. Creature.
As to the arraignment, Your Honor, we ask the court to waive the formal reading of the information, and we stand mute, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
Judge Conlon.
August 5th, 2026, 1:30 before Judge Conlon. Bond
Thank
continued.
you. Thank you, Your Honor.
She's like, once.
Absolutely.
I don't want that. We need to get into a fight.
And I'm sorry.
Court to call the case, People versus Lewis McSwain.
Actually, those is for the vehicle.
Good morning, Your Honor. William Amadeo, P719, with Mr. McSwain. He was here. He was right. I apologize, unless you passed, he was here. I went to the bathroom.
What if I said no? You're walking away.
You're the boss. I'll say.
I know. Didn't act like it.
And I apologize.
Showed up. I knew he was here. He was telling me to bench warrant you.
That's not true.
What? And I said, no, I'm not doing it. I was looking out for you. All right, what are we doing?
We're proceeding to preliminary examinations.
Discovery is complete.
Yes.
And would the people have their witnesses available the 21st?
Yes, sir. We'll try for that date. Thank you.
All right. Preliminary examination in person will be set for July 21st, 2026, 9 a.m. before Judge Moore.
Thank you.
Bond will continue. Thank you. Court calls the case of the People versus Josiah Miller.
Actually, this is for the vehicle.
Appearing on behalf of the defendant. Your Honor, I heard what the court said earlier. I do think there's a conflict in this court. Ms. Feltus thinks my client is guilty and I don't.
There's always a conflict then.
State your name, Josiah.
Miller.
Your Honor, we're going to be waiving exam. My client has to sign the waiver form.
All right. So you're waiving your right to a preliminary examination?
Sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on the signal.
My client waives the reading of the information in this matter, Your Honor. My client stands mute, asked that a not guilty plea be entered.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 28th at 1:30 with Judge Humphrey.
July 28, 2026, 1:30.
All right, thank you, Your Honor.
Thank you. Bond continues. She's stalking. Court calls the case. People versus Lance Ford.
To the people, Your Honor.
Trophy on behalf of Mr. Ford. He's in the hallway.
That doesn't do me much good.
That doesn't. I'll go grab her.
About the time.
Your Honor, Mr. Ford, state your name.
Lance Ford.
Your Honor,
Yes.
I've spoken to Mr. Ford. We're asking to not actually follow the green sheet. Mr. Ford. Mr. Ford, again, this morning, I spoke to him yesterday. We spoke again this morning. He wants to set this for an exam.
It's not a weapon. Is all discovery complete?
And that is, Your Honor, I've explained to my client that I don't have a full discovery. My client is adamant that we set this matter for an exam. I explained to him the normal course is for me to ask for a permit so I can discovery, which I would have good cause to do. But Mr. Ford wants to set this matter for an exam.
Is that right, Mr. Ford? Even though your counsel is saying he doesn't have everything that he needs?
Yeah, I was trying to move forward process.
People have their witnesses available the 28th. Preliminary examination in person will be set for July 28th and 26th noon. That's before me.
That's what you just said, preliminary exam.
If you guys aren't ready to go, I'm not gonna entertain an adjournment or anything along those lines because you don't have discovery.
I 100% agree.
You'll just sleep in the bed that you want to lie in. Thank you. Bond continued.
Thank you, Your Honor.
Court calls the case, People versus David Sarpo.
And Lisa, on behalf of the people, Your Honor.
Good morning, Your Honor. William Amadeo, P76194 for Mr. Starpo, who will be coming up standing to my right. David, when you approach, please state your name for the court.
David Sarpo. Thank you.
Morning, Your Honor. My client and I met last night. He wants to proceed to a preliminary examination.
Discovery is complete.
Yes, sir.
People have their witnesses available the 21st.
Starbucks, Your Honor.
Preliminary examination in person will be set July 21st, 2026, 9 a.m. before Judge Barr. Bond will continue.
Thank you.
Court calls the case, People versus Deshawn Jones.
Go for the people.
Morning, Your Honor. Edward Drugas on behalf of Deshawn Jones.
Deshawn Jones. Thank you.
There's a green sheet in the file. We'll be asking for an adjournment. We're close to setting up that meeting that we've been working on.
You're trying, okay, but so how much time do you need?
Shoot, it's been sort of a hiccup because the original OIC retired and you're trying to figure out how to schedule the new OIC and all that. I think 2 weeks will give us something to figure out a plan. We'll be able to actually schedule the poly given all the shuffling of the agency.
Got it. Probable cause conference, July 23rd, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Devon Thompson.
Go to the people.
Ounces in zone.
Your Honor, good afternoon. Marcia Crater on behalf of Mr. Thompson.
Your name?
Devon Thompson.
Thank you. What are we doing?
Your Honor, we'd be requesting pursuing a preliminary exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 21st.
Do our best, Your Honor.
Preliminary examination in person will be set July 21st, 2026, 9 a.m. before Judge Moore. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case of the People versus Scott Kidney.
Good
morning, Judge Carpenter on behalf of, but not with Mr. Kidney. May we approach?
Were you gonna do this all day?
Yeah, I only got one more.
Yeah. You just start walking out. Alan will take you down in a minute. Come on.
Just about one of the few guys about my height.
Can you get your polycom, Your Honor?
Reflect we had a bench conference in this case. Probable cause conference will be adjourned to July 28th, 2026, 9 a.m.
Thank you, Judge.
Thank you. Bond continue. What are you two doing? Court calls the case, People versus Aaron Burrows.
Your Honor.
Brother Judge, Marshall, please refer to Assistant Public Defender on behalf of Mr. Aaron Burrows, who is approaching the podium. Mr. Burrows, when you arrive, please state your name for the record.
Aaron Burrows.
Thank you, Judge. According to the note file, this matter is supposed to be have a plea resolution. but we have not been able to get that completed and into court before today's date. We'd be asking for a brief adjournment to get the plea resolution into the court.
So you've already resolved it. You just have to get the paperwork in.
That's what the notes indicated, but I haven't talked to Ms. Dover about it.
I wasn't able to find anything in my file to reflect that. I'm not saying it's true. I'm not sure.
Cannon put those notes in, didn't
Can I plead the fifth?
I just. Well, why don't I do it this way? What's only being held on this case, or?
I believe so, Judge.
Then what I'll do, try not to delay the matter. I'll adjourn it out to the 16th.
Thank you.
Have a deal, and then you can figure out what to do.
Thank you, Judge.
July 16th, 2026, 9 a.m. Bond continued. Court calls case of the people versus Daniel Polgar. We're done.
Covered all on behalf of Ms. Polgar. No need to approach.
Well,
No, not on this one.
thank
Who's taking it for the record? Daniel Polgar. Just an adjournment, please. From the podium.
from the podium. Your other matter I set for the 28th, you want me to put it then?
Yes, please.
That work for you. Probable cause conference will be adjourned July 28th, 2026, 9 a.m. Bond continued.
Thank you.
And thank you, Judge.
Thank you.
Let me show my home.
Court calls case people versus Sean Charley.
Thank you,
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Charley.
That's gonna go better than the last one you had.
I'll do my best, Judge.
Your name, sir? Sean Charley. Thank you.
Your Honor, I'm going to ask to set each matter for preliminary at this time.
Discovery is complete.
I believe so, Your Honor.
People have their witnesses available the 21st. Preliminary examination will be set July 21st, 2026, 9 a.m. before Judge Barr. Bond continued.
Thank you, Your Honor.
Court calls case people versus Angela Ball.
Brian Bowley on behalf of Ms. Ball, Your Honor.
State your name for the record, please, Ms. Ball.
Angela Baum.
Your Honor, we're asking for an adjournment in this matter. We're waiting some outstanding discovery.
Probable cause conference. And will all that be clarified by the 23rd? All right. July 23rd, 2026, 9 a.m. Found continued.
Thank you, Your Honor.
Thank you.
Step back behind the bar and I'll be right there.
Court calls for cases of the people versus Grant Deia. Or DK, excuse me.
Good morning, Your Honor. Ashley Hannibal for Mr. Deshawn.
Morning.
Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of, I don't see Stephanie Cannon here.
That's probably good.
Torshio Feaster.
All right. Permission to practice is granted.
All right, thank you. We are requesting an adjournment in this case. And I don't have a green sheet for all of those when she went out into the hall.
I get you threw her under the bus, didn't you?
Yeah.
I need two.
All right.
You know how much time you need?
2 weeks.
All right.
Can I get the phone?
Any objection from the people?
Oh, you're on.
Probable cause conference will be adjourned Tuesday, July 23rd, 2026, 9 a.m. Bond continued. Thank you.
Can we recall this case later to make a bond argument?
Negatory ghostwriter, but why do you want me to call it later?
I haven't discussed with the client, like what we would be arguing there yet. Oh,
Sorry, I'm done.
all right.
Sorry.
Can't do that with somebody in custody because of taking them back and at some point taking back up.
Mr. Josiah, I'm so sorry, Your Honor. Things went bad. I had to step away for a second.
Well, nice to have you back.
He was in the hospital. I actually went to visit him in the hospital. They said you can't do that. Then I scheduled a Zoom meeting with you and they said, our bad, he got released. You can't Zoom with him. And now he's here. So I did speak to the lieutenant, Your Honor. And what I would like to do is adjourn today's date so I can talk to him about his matters. There's been an offer extended. But in addition, I'd like to address bond, Your Honor. My client is, I'm sorry, he has a lot of medical needs. He's been in and out of the hospital since he has been a part of the system. Your Honor, my client, we're asking that he be released. We want to put him on tether home confinement. We would be fine with that as long as he has the ability to go to all the medical appointments that he has. Yes, there you go. Sorry.
Yeah. The events the defendant committed while he was on the bond or going to have status of his other pending cases. Fully honored $1,000. Leave the bond on these matters is 1,010%. I think that's important.
And
Anything else?
so, Your Honor, that's my argument.
Motion for bond reduction is denied. Bond will continue.
Thank you.
I did 3 times and it failed.
Thank you. Court calls the case of the people versus Deia Banbury.
Jacob Kennedy, for the people, Your Honor.
Stephanie Cannon on behalf of Ms. Banbury, but not with, Your Honor. She was recently released from the mental health facility. When I spoke to her yesterday, she was going to come in, Your Honor. She is trying to get here. She doesn't have a vehicle, but she had recently been released from the mental health board. So I'm just asking for an adjournment, Your Honor, or at least if we could push this to the side so I can call her and get her here.
Second, third, fourth failure to appear on this case, so I'm informed.
Wow.
Your Honor.
Kennedy did that.
He did, but Your Honor, all of these, for these processes, she has been involuntarily committed. So these are the reasons why she has not appeared. And we were able, I believe the reason we were able to get the report recalled is because of that. And we were able to show proof of that. So this is not a case where she's just not coming. This is just a simple matter of mental health needs. So if you would just set it aside, Your Honor, so I can give her a call and have her come in, make sure she's getting here. I am dying. I don't know.
No, don't say that.
Please.
Okay. Oh, I'm going to set it. I'll pass it briefly. Take a little bit of time to get her here.
I will.
Yeah. That's when you pass my case. I'm dying. Court does call the case. People versus Maisha Gaines.
I'm sorry. Ready again, Judge. Torshell Feaster, Assistant Public Defender on behalf of Ms. Maisha Gaines, who will stand to my right at the podium. Please state your name for the record.
Maisha Gaines.
Thank you.
Thank you, Judge. This is a similar case to the last one I had where we need to get our police report in for no contest plea, and we're not able to get that done before the deadline. So we're asking for an adjournment to be able to get that in.
Probable cause conference will be adjourned to July 16, 2026, 9 a.m. Bond continued.
Thank you very much, Judge. If you adjourned it, plea enter next court date based on all the information I had to send in to them.
Ma'am, I need certain paperwork. They're going to get it to And that's all, instead of 2 weeks, I've adjourned it out just 1 week.
Okay. All
Okay?
right. Thank you.
Thank
You're
you.
welcome. Court does call the case. People versus Malachi Everly.
Your Honor. Your Honor, Amy Lucas, requesting permission to practice under Michigan Court Rules 8.120 under the supervision of Assistant Public Prosecutor Jay Bellinger.
Permission to practice is granted.
Could you please state your name?
Malachi Beverly.
You got him.
Your Honor, are looking to enter a no.
Hold on a second. You got him.
Yes.
Okay. Go ahead.
We're looking to enter a plea today.
I have before me a plea form that indicates that the defendant will be pleading no contest to 3 charges.
That's my understanding.
Count 2 is domestic violence, a 93-day offense. Count 3, assault and battery, also a 93-day offense. Count 4, malicious destruction of personal property, 200 to 1,000, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. Defendant is agreeing to complete a substance abuse assessment and follow all recommendations, including inpatient treatment or outpatient treatment. The prosecutor and defendant are agreeing to a sentence agreement of sentencing for count 2 under 7694A and for counts 3 and 4 under a prosecutor's deferred. That is the court's full understanding of the agreement.
That's correct, Your Honor. That's my understanding as well.
Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
State your name.
Malachi Beverly.
Okay, you can put your hand down. Sir, it is this court's understanding you're going to plead no contest to 3 charges. First charge is the added count 2 of domestic violence, or actually stated count 2 of domestic violence. That's a misdemeanor punishable by up to 93 days in jail, a $500 fine plus court costs. Do you understand that, sir?
Yes.
Also, that you'll be pleading no contest to the charge count 3 of assault and battery. That's also a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
And also no contest to malicious destruction of personal property, 200 to 1,000. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken if that's greater than 2,000 or destroyed. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
Do you understand what a no contest plea is?
Yes.
2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest these charges. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, Your Honor.
All right. Basis for the no contest plea?
Liability.
Sir, to the charge of domestic violence, how do you plead?
Guilty.
No contest.
No contest, I mean.
To the charge of assault and battery, how do you plead?
It's all no contest right now.
Yes, no contest.
Okay. So to that charge, you're pleading what, sir?
No contest.
Okay. To the charge of malicious destruction of property, how do you plead?
No contest.
Now you understand that by pleading no contest, you will not have a trial of any kind.
Yes, Your Honor.
You signed or had cause to be signed on your behalf an advice of rights form. Is that correct?
I think I did.
Well, did you?
Yes.
To the court.
All right. Do you have any questions regarding any of those rights?
No, Your Honor.
You understand that you're waiving or giving up all of those rights, including the rights under paragraph 5, which are your trial rights.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you in any way?
No.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
All right. Court has been provided and has reviewed Washington County Sheriff's Office report for their case number 26-37598. Any objection to the court having reviewed that report?
No.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Sir, I do have to advise you that if between the time I accept your pleas and the time of sentencing, if you commit misconduct as defined in the Michigan court rule, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that, sir?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to counts 2, 3, and 4. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
July 30th at 9 a.m.
July 30th, 2026, 9 a.m. before Judge Barr.
Thank you, Your Honor.
Bond with its conditions will continue. Thank you. Court calls the case People versus Dontrell Smith.
Morning, Your Honor. Raymond Cook to the people.
Good morning, Your Honor. Assistant Public Defender, Aker on behalf of Mr. Dontrell Smith.
Boy, I was waiting for you to show up.
Good morning, Judge.
Good morning. Mr. Smith?
Yeah.
Can you state your name for me?
Dontrell Smith.
Thank you. What are we doing?
So, Your Honor, I don't think we have much that we can do today. We're waiting for a competency report. I did receive the letter from the Forensic Center indicating they were needing about a month. They still had some documentation that they needed to get.
All right. I'll adjourn the competency hearing then to August 3rd, 2026, 9 a.m. Bond will continue. Thank you, Mr. Smith. Court calls case People versus Robert Jameson II.
Brian Bowling on behalf of Mr. Jameson, Your Honor. Hey, morning. Can you state your name for the record, please?
Robert John Jameson II.
Your Honor, I'm asking for an adjournment of this matter. It's my understanding that Mr. Jameson was referred for screening for the Circuit Court Recovery Court in another matter. If you want, sorry.
It's screened already, or?
I do not believe so, no.
Have you been screened?
Told me they would be doing screening. I don't believe I have been yet.
He hasn't met with anybody yet, Your Honor.
I met with one person about.
If the next pretrial before Judge Soleil is set for the 23rd in the afternoon, if that helps at all with the court.
Yeah, well, thanks, because I was looking at timing of it. You want, and that's the case that he's being screened for?
That's correct. That is correct.
I asked for the 30th this week.
Okay, I don't have the 30th. I have the 28th. That'll work. All right. Probable cause conference will be adjourned to July 28th, 2026, 9 a.m. Bond.
Thank you, Judge.
Yep. Thank you.
Thanks, Judge.
Court does call the case. People versus Angelina Bonacera.
Asli Bashir on behalf of Angelina Bonacera, but not with, Your Honor. I was informed by Washtenaw County Jail staff that last evening Ms. Bonacera was transferred to Monroe County Jail. Are they on Zoom?
So she's been transferred?
Yeah. last evening, I think, ex-jail says around 4:30.
All right. Did they say is she coming back or we don't know?
He's being held, actually, may I approach, Your Honor?
Yes. Record should reflect we've had a bench conference in this case. I will adjourn the probable cause conference why don't we just set it for the 28th? And we'll see where we are, 9 a.m. Bond continued.
Yeah, we'll try for that. Good.
All right.
Your Honor.
Court calls case People versus Joseph Lovely.
Right, those people, Your Honor.
And Assistant Public Defender on behalf of Mr. Lovely, who approaches. Mr. Lovely, can you please state your name for the record?
Joseph Graham Lovely.
And I am just asking for an adjournment on this matter. I've talked to Ms. Dover about this case. It sounds like we're both on the same page with regard to our ask for release to inpatient treatment, contingent, and that would be contingent upon his successful completion with regard to an offer. We're just seeking to get him in as soon as possible somewhere.
What, 2 weeks or you want longer?
I think, I understand. I think 3 weeks would be more appropriate, Your Honor. I can get the paperwork in for today.
I don't quite have 3.
That's right.
28.
The 28th would be fine.
All right. I'll adjourn it to July 28, 2026, 9 a.m. Bond will continue. Thank you.
All right.
Court does call the case versus Tasha Brazelton.
Bring the complete people.
Brian Bowling on behalf of Ms. Brazelton. Can you state your name for the records, please?
Tasha Brazelton.
Thank you.
Your Honor, we're asking for an adjournment. I think we have a resolution in this case. We just need to finalize the paperwork.
Hearing probable cause to July 23rd, 2026, 9 a.m.
Perfect. Thank you, Judge.
Thank you. Your cubs? You like to? Anyways, okay, you can stay. All right. Court calls the case of the People versus Marcus Olaf.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Ola. Mr. Ola, could you please state your name for the court?
Marcus Ferns Ola Jr.
Your Honor, I've completed a green sheet. We are requesting an adjournment. I believe that we expect to receive additional evidence from the crime lab in this case.
Okay. So you're looking for additional discovery?
I believe so, Your Honor.
Do we have any estimation as to when that might happen or?
Only I can sit there. No, we process that process that crime lab, but given that the Northville lab just closed, I don't know how long.
Turn it to July 28th, 2026, 9 a.m. That's a Tuesday. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus DeAnthony for
People.
And Alex Warren Green on behalf of Mr. Buford. What's your name, sir?
Yeah, it was Buford. I'm sorry. Why not? Everybody else has. Yep. Come on.
Okay, this is where things get serious. Mr. Buford and the prosecution just dropped a bomb. 15-minute phone calls, multiple contacts with the victim after arraignment. That's not just a bond violation. That's potential witness tampering, and Judge Simpson is not having it. Look at the detail here. 14 minutes, 25 seconds. 15 minutes, 14 seconds. He's counting the minutes, folks. Defense is scrambling, trying to paint this as concern for the victim's welfare, but Judge Simpson is seeing right through it. He's revoking bond, pulling phone privileges, everything.
Record should reflect we've had a bench conference in this case. Who wants to go first?
I would respond. It came to my attention that Mr. Buford had contacted them
5 times after being arraigned, exclusively after being arraigned from other inmates. And so at this time, given that he violated his bond, I'm going to be asking for him to be remanded and that his phone privileges while in custody be revoked.
Mr. Allen, please.
And Your Honor, Ms. Zenda relayed that information to me this morning, and I believe the people are working to get the phone calls over to us. I haven't had the benefit of reviewing those for their subject matter or the times those calls were placed. However, Mr. Buford admits to contacting the complainant while he was in custody.
Post arraignment.
I can't corroborate that at this point, Your Honor, and I'd ask to come back on the 16th when I've had the ability to do that. What I would ask the court to consider, Your Honor, is that Mr. Buford's 27 years old. I don't believe he has any criminal history, and see that he has 2 open pending traffic matters, but certainly nothing assaultive or felonious. Mr. Buford is employed full-time, and he has stable housing apart from the complainant. Part of the bond that was set in this case involved a hot zone tether, and I think subsequent to his release, I don't believe there have been any additional allegations of misconduct while on bond. So I'd ask the court to consider continuing his bond at this time pending a hearing on the 16th, Your Honor, or a probable cause conference on the 16th.
My understanding is you have them post arraignment.
Correct, Your Honor. I believe they're exclusively post arraignment. He was arraigned on the 27th, and the calls begin, the completed calls from other pins begin on the 28th and go into the 29th.
And these aren't 1-minute calls, as I understand there's
14 minutes, 25 seconds, 15 minutes, 14 minutes, 36 seconds, 15 minutes, 15 minutes. Full duration of the calls that you get while in custody is 15 minutes.
Your Honor, I have absolutely no reason to doubt that. I just want to make sure that I'm complying with my duties to corroborate that information.
I understand. What I will do is probable cause conference will be adjourned to the 16th, 2026, 9 a.m. Defendant, he's not really admitting to the violations because you don't have the timing other than what the people have indicated, but they given the court enough. Defendant's bond at this time is revoked. Defendant's demanded. I'm also revoking phone privilege. He has in the jail that includes texting.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case, People versus Lee Pat.
And then on behalf of the people, Your Honor.
And Alex Warren Green on behalf of Mr. Patton.
Okay.
The Honor, Pat.
Thank you.
Your Honor, my understanding is Mr. Patton wishes to waive his right to a preliminary examination waiver form before me. And I believe people have indicated upon his waiver, they will not be seeking any habitual offender sentencing enhancements in this case.
And then the director that we want to speak for a minimum of 25 years.
Got it. So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding that where the people would have to show by the standard of probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. People also waive their right. Preliminary examination having been waived, defendant is bound over to circuit with 7 followed.
Your Honor, we acknowledge receipt of the information, waive its reading and stand mute. I have a paper waiver for the court.
Waive from a reading, standing mute. Court will enter a guilty plea. Pretrial will be set for
1:30 with Judge Simpson.
July 20th, 2026, 1:30 for Judge Hamoud. Bond will continue.
Thank you, Your Honor.
Same information.
No. Yes. Let me make sure I got one. I do. Court calls the case, People versus Ted Butler.
Check your candidates for the people you're on.
Good morning, Your Honor. Ashley Handel for Mr. Butler. But not with Mr. Butler. There seems.
All right. And court will issue defendant's failure to prepare bond is set him at 10,000.
All right.
Yeah, get rid of me. Yeah. Nice try.
Got that.
Yeah. Court calls the case, People versus Devon Reed. You learn anything?
Ashley Jones for the.
Oh, what'd you learn? There. Yes.
Amy Lucas on behalf of Your Honor.
Henri,
We're looking to set for PE.
Discovery is complete.
That's my knowledge.
People have their witnesses available the 21st.
Try to.
Preliminary examination will be. Yes.
Oh,
Preliminary examination will be set.
oh, Your Honor. So sorry. We also, we
Interrupting me.
I'm sorry, Your Honor.
No, you're not.
Not really, no.
Whoa, really? Wow. I don't know. I didn't think that tiger had earned its stripes yet, but I no, she meant it. Meant it. You know the reason I know she meant it? Because she's normally very nice and everything, but then Cannon got it right. And that's the only reason this is here. But it's okay. All right. That's fine. I got thick skin.
Wait till that's done.
Okay, go ahead.
Your Honor,
You're good. Don't worry about it. They're in trouble. You're not. Well, you are, but all right.
we're also looking for release for treatment today.
You interrupted me for that? What did I do in this case? Setting it for exam?
You didn't even give a judgment.
I didn't even get a chance to do that, did I? She was arguing bond, right? Is that what I heard?
Oh.
So it got confusing. This is why I can't get things done. All right, first thing, I'll set discovery is complete. Yes?
Yes, Your Honor.
All right. Miss Cannon has nothing else to add to what you're doing.
I hope not.
Just fine. Probably could have done very well without her interference. Preliminary, people have their witnesses available the 21st.
We'll try for that today.
All right. Preliminary examination will be set July 21st, 2026, 9 a.m. in person before
Judge Moore.
Judge Moore. People have any objection to release to treatment?
Yes, Your Honor. The defendant previously failed to appear in February this year and was gone for several months. He also earlier this month admitted to absconding from probation supervision in circuit court. And I think he did get a release to treatment there, but I would ask that the court not allow him here, given his taking up a case while he had the circuit court case pending into exam probation and then failing to appear, having a bench warrant.
But if I'm understanding you correctly, he currently has a release to treatment in circuit court.
His probation was reinstated and he got 60 day jail, zero credit balance suspended on release to Bear River specifically. So it's only Bear River that he got on release to. I don't think he has a date.
Well, okay. I understand what may be the people's position. You submit an order to the court, consistent with the circuit court's order. I'll allow release to Bear River.
Thank you, Your Honor.
All right. Thank you.
Your Honor.
You gonna get that order to me today?
Yes, yes.
I'm not talking to you.
Oh, yes, Your Honor.
All right, good enough. Court calls the case, People versus LaShawn Charles.
Raymond Cook for the future. The Assistant Public Defender Jay Bellinger on behalf of Ms. Charles, who should be in appearance via Zoom. Ms. Charles, can you please state your name for the record?
LaShawn Charles.
I have before me a plea form that indicates the defendant will be pleading to an added count 2 of an attempt embezzlement, 200 to 1,000. That'd be a no contest plea. That's a 6-month. Butner, plea to that charge, count 1 would be dismissed. Defendant is agreeing to pay full restitution.
That is my correct understanding of the offer, Your Honor, as well as my client's.
That's correct, Your Honor.
Attempt embezzlement?
Yes, Your Honor.
There's a reason for it.
Who were involved in this?
Yes, Your Honor.
Okay. All right, I get it.
That's how you know you can trust it.
It's involved.
Not what I was thinking. All right, ma'am. Can you raise your right hand? Is that your right hand? Is your camera
Sorry.
reversed? The one without. There you go. All right. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
State your name for the record, please.
LaShawn Charles.
All right. You can put your hand down now.
Thank you.
All right. Ma'am, it's this court's understanding that you're going to be pleading no contest to the charge of attempted embezzlement, 200 to 1,000. That is a misdemeanor punishable by up to 6 months incarceration, a $1,000 fine plus court costs. Fine could be increased if 3 times the value of the property taken. If that's greater than $1,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
2 things about it I have to make sure you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. Understand that?
Yes, sir.
The second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. I do also have to advise you that while I'm taking your plea, I would not be your sentencing judge. You would be sentenced before Judge Perry in the 15th District Court. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea?
Potential civil liability, Your Honor.
Right. Ma'am, to the charge of attempted embezzlement, 200 to 1,000, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind?
Yes, Your Honor.
You signed an advice of rights form or had one caused to be signed on your behalf?
Yes, Your Honor.
Any questions regarding that form?
No, Your Honor.
You understand that you're waiving or giving up the rights contained on that form, including the rights contained under paragraph 5, those being trial rights.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
Right. Court has been provided and has reviewed Ann Arbor Police Department report for their case number 2531637. Any objection to the court having reviewed that report?
People?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be
July 31st at 8:30.
July 31st, 2026, 8:30 before Judge Perry. Bond will continue. Thank you, ma'am.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Akim Sanders.
That's public for people.
System Public Defender, Charley Aker, on behalf of Sanders. Let's just stand and state your name for the record, please.
Akeem Ali Sanders.
You're requesting a forensic value.
That's correct, Your Honor.
Forensic evaluation is ordered. I'll set a competency hearing for October 8th, 2026, 9 a.m. Bond at this time will continue.
Okay.
Thank you. Court calls the case People versus Quinteria Cummings.
Rest of those for the people. Sharon Thompson, coming.
And I have Your Honor, we're requesting an adjournment for matter.
Your name?
Harriet Cummings.
How much time are you gonna need?
I think 2 weeks should be sufficient.
Probable cause conference will be adjourned to July 23rd, 2026, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus John Smith III. She said, move.
Your Honor, Revoked people.
She's yelling at you. She is. She's screaming.
And Alex Warren, agreeing on behalf of Mr. Smith. Mr. Smith, can you state your name for the court, please?
John Smith III, Your Honor.
Thank you.
Your Honor, at this time, I'm asking the court to set the matter for preliminary examination.
Is discovery complete?
Believe so, Your Honor.
All right. People have their witnesses available the 21st.
Your Honor.
Preliminary examination, July 21st, 2026, 9 a.m. before Judge Barr. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls the case People versus Jerry Doss.
Morning, Your Honor, Revoked for the people.
Assistant Public Defender Zach Vignew with and on behalf of Mr. Doss, who is present via Zoom. Mr. Doss, can you please state your name for the record?
Yes, Jerry Doss.
Your Honor, we're seeking an adjournment. We were not able to meet with Mr. Doss. He does not have a phone or contact information, but was able to come to the 14A2 District Court today to get on Zoom. So we are setting up a time next week to request an adjournment.
2030 be enough time for you?
That should be enough. Thank you.
Probable cause conference adjourned July 23rd, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
As fast as I can. Just don't yell. Court does call the case People versus Jason Szymanski.
Your Honor, Revoked for the people.
First assistant, moving further on the with the podium. Please state your name for the record, sir.
Jason Alexander.
Thank you, Judge. My understanding is that Mr. Szymanski has already been referred to our AIM Social Work Division. They are in the process of preparing a mitigation report, and we are requesting an adjournment.
July 28th, 2026, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case People versus Robert Burrows.
Possibly to share on behalf of Robert Farag, but not with. I've received I believe Miss Attorney Zenda initially notified me, and I have followed up. Mr. Farag was extradited to Alachua County, Florida on Tuesday. To Alachua County, Florida. I don't know where that is.
Okay.
But it appears that I do know what his destination facility is. I've emailed opposing counsel in the court. I would request an adjournment.
Bench warrant will issue for defendant's failure to appear. Bond will be set in amount of $10,000 cash surety.
All right. Your Honor, I believe Washington County Jail extradited him to that jurisdiction. If that makes any difference.
Fine job they've done. I mean, I don't know what
I see.
What am I supposed to take from that?
Sorry. Yeah.
All right. Thank you. Court is the case People versus Justin Taft. Yes, ma'am.
Judge Torshall. And on behalf of Mr. Taft, who is approaching the podium. Mr. Taft, when you arrive, please state your name for the record.
Justin Taft, sir.
Thank you, sir.
We go to waive circuit court. Thank you, Judge. Mr. Taft is executing the examination waiver. We tender that signed paperwork to the court.
Sir, you're waiving your right to a preliminary examination?
Sir.
You understand that that's a proceeding where the people have to show by probable cause that the offense alleged was committed in the,
Yes, sir.
you understand you won't have that here, you'll proceed to circuit court for further resolution.
Sir.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on the single count.
Thank you, Judge. He'll waive formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
July 20th at 1:30 with Judge Simpson.
July 20th, 2026, 1:30, Judge Hamuth.
Thank you.
Girls, set today for bond violation.
That's my understanding, Judge.
Because at this point in time, trying to look for it. He never.
He walked away.
Left treatment, Your Honor. He's acknowledging that, Your Honor. He admits left treatment. Mr. Lebo did have a substantial conversation with him about the circumstances around that I would like to notify the court of, if I might. Mr. Lebo indicated that Mr. Szymanski left treatment because he was suffering from severe anxiety. He felt that that the treatment was not adequate. He says that he had much better results through the VA at Battle Creek. He indicates that the client called the tether agent and left a voicemail notifying her that he was leaving treatment. He understands that he should not have left treatment and that he should have called his attorney instead. And he apologized for making that decision, Your Honor.
How did we get him back into custody?
My dad came over with the sheriffs.
Okay. His father brought the sheriffs over and they brought him back into custody, Your Honor, from his father's house.
Because he was supposed to be here on June 25th. And he didn't appear on that day.
Yes, sir. I understand.
All right. His bond will continue as revoked. And I'll let, who said before Hamoud?
Yes, Judge.
I'll let Judge Hamoud deal with that. I'll accept his admission. Let her deal with any sentencing on that.
Thank you very much, Judge. All right.
Court does call the case of People versus Juanita Glaspie.
Assistant Public Defender Jay Bellinger on behalf of Ms. Glaspie, who appears via Zoom. Ms. Glaspie, can you please state your name for the record?
Juanita Glaspie.
Had before me a form indicates that the defendant will be pleading guilty to the charge of retail fraud second, the 1-year offense. Upon our successful plea to that charge, retail fraud first will be dismissed. That's the court's full understanding of the agreement.
That's correct.
That is our understanding as well, Your Honor.
I'm going to correct the form because it doesn't need to be a sentencing judge waiver.
Thank you very much.
All right. Ma'am, can you raise your right hand, please?
Yes, Your Honor.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right. State your name for me.
Juanita Glaspie.
All right. Ma'am, it is this court's understanding you are going to be pleading guilty to the charge of retail fraud second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court cost. The fine could be increased if 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. And understanding that, you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll giving up your right to a trial.
Yes, Your Honor.
All right. You signed an advice of rights form, is that correct, or had one signed on your behalf?
Yes, Your Honor.
Do you have any questions regarding any of those rights?
No.
You understand that you're giving up all of those rights, including the rights contained in paragraph 5, your trial rights?
Yes.
You understand you're giving up your right to appeal upright?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're indeed guilty of this offense?
Yes.
On April 27, 2026, at the location of 7,000 East Michigan Avenue in Pittsfield Township, Washington County, State of Michigan, what did you do at the Walmart that makes you think that you're guilty?
Walked out with their merchant, but they got their merchant back.
Okay, but you went into the store?
Yes.
All right, and you picked up merchandise and tried to walk out without paying for it?
Yes.
The store was open to the public at the time?
Yes.
You didn't have anybody's permission from Walmart to be able to walk out of the store with that property, did you?
No.
All right. And are we doing this on value or prior?
Value, I believe.
Okay. And ma'am, was the total value of the property that you tried to walk out for, was that in excess of $200?
Yes.
Okay. Ma'am, I do have to advise you that between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in this matter will be August 12th, 2026, 9 a.m. before me.
Thank you very much, Your Honor.
All right. Bond will continue. Thank you.
Thank you.
Court does call the case, People versus Stephen Huska.
Second, on behalf of Mr. Huska, who should be appearing by Zoom.
Sir, state your name. Okay, we'll wait. Oh. How long has she been there? An hour? No, she never ships up that early. No, I got the lilies mixed up. Lily Ann. Really? I thought you were used to me. Apparently.
Your Honor, I can attest to the fact that that is my client. We have met with each other before.
Think I'd believe that?
I wouldn't.
Okay.
Okay, sorry about that.
No, it's not a problem. Can you state your name, please, sir?
Okay.
All right. All right, what are we doing?
Your Honor, we're going to go ahead and set his case for a preliminary exam. There's no forthcoming at this level.
All right, where is he?
He is in
County?
Huron County Jail.
All right. Discovery is complete.
Yes, Your Honor.
How long you're in Huron County Jail, sir?
Yes,
How long do you expect to be there?
September 18th.
September?
Yeah.
Okay. So let's do this. Give a little bit more time. Would the people have their witnesses available the 28th? Preliminary examination will be set in person July 28th, 2026, 9 a.m. before Judge Freshour.
You said July 28th?
Yes, sir.
Okay.
Thank you so much, Your Honor.
All right, thank you. Court calls the case, the People versus Quintez Tomlin.
Your Honor, reading to the people.
Assistant Public Defender Jay Bellinger on behalf of Mr. Tomlin, who should be coaching, Your Honor.
Here. Give this to me.
Mr. Tomlin, you please state your name for the record.
All right.
And Your Honor, my office is working pretty tirelessly. I'm working with Ms. Gaines to try to get an independent evaluation scheduled for this client. We just need a little more time in order to try and do that. I've made several phone calls to 3 different vendors within our office, and unfortunately, some of the timeframes I'm getting are in September, and that's just not going to work.
Want the 28th or August 6th?
I think August 6th would be appropriate.
All right. Probable cause conference turned August 6th, 2026. Bond continued.
Thank you very much, Your Honor.
Little more.
All right, Mr. Tomlin, we'll be in touch, okay?
I don't know. She told me.
We just tossed him like a frisbee.
Oh, she yelled at me, and then I had to do something different. Whole thing got messed up. I don't know what happened. What? I mean, yes.
Oh, that's right. She's not.
That was canon.
I mean, maybe I'm
No, she is. She is coming. Most of it way. Court calls the case, People versus Xavier.
Assistant Public Defender Zach Vinue with and on behalf of Ms. Greer, who is present via Zoom. Ms. Greer, please state your name for the record.
Xavier.
All right, I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000 1 year. Upon a successful plea to that charge, count 1 would be dismissed. There is not. It just says defendant is seeking prosecutors deferred. That will be determined at sentencing.
That's correct, Your Honor. So it's not an agreement, but it's just put on there.
Put on there for that purpose. Very good. Thank you. All right. Is that a correct statement, Counsel?
Yes, Your Honor.
All right. Ma'am, please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Xavier.
All right, you can put your hand down. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of malicious destruction of personal property, 200 to 1,000. That is a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property destroyed. If that's greater than 2,000, that becomes the maximum fine. You understand that?
Yes.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Still wish to plead guilty?
Yes, I do.
And to that charge, how do you plead?
I plead guilty.
You understand that by pleading guilty, you'll not have a trial of any kind?
Yes, sir.
You signed or had cause to have signed an advice of rights form on your behalf?
Yes.
Do you have any questions regarding any of those rights?
No.
You understand that you're waiving all of those rights, including the rights contained under paragraph 5, which are your trial rights?
Yes, I do.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you're guilty of this offense?
Yes.
July 4th, 2025, at the location of 1308 Jones Street, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do on that date that makes you think that you're guilty?
I hit my cousin's car with my car.
Okay. Nothing like close family. You did that on purpose?
I did.
All right. And what did you do? Just ram the car?
I did.
What? And like I said, you did that intentionally?
I did.
And there was damage to the other vehicle?
Yes, sir.
How much damage? Was it in excess of $200 worth of damage?
I believe so.
What were you driving?
I was driving a 2021 Ford Escape.
What was the car you hit?
A Mercury, I think like a Merit. It's like a truck.
Okay.
It's like it looks like an Escape, kind of. I don't know.
It's a Ford battle. I was just hoping it had
Basically.
been. All
Well,
right.
yeah.
Okay. All right. You'd stipulate that the amount of damage is in excess of $200.
We would, Your Honor.
Yes, Your Honor.
All right. Ma'am, I do have to advise you between the time of my acceptance of your plea and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea, and the court would not be bound by any sentence evaluation or recommendation. You understand that?
I understand.
All right. Counsel, are you aware of any other promises, threats, or other inducements that have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
You have, Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B. Probation sentencing will be
August 13th at 10 a.m.
at 13th.
13th.
August 13th, 2026, 10 a.m. before Judge Washington.
Thank you.
Thank you. Bond will continue.
Thank you, Your Honor.
Have a good
Thank you,
one.
All right, you too.
Thank
Drive
you.
safe.
Thank you.
Court calls the case, People versus Keith Watley.
Are you ready?
Ready, Judge. Torshell Heaton, first assistant public defender on behalf of Mr. Watley. Mr. Watley, when you arrive, please state your name for the record.
One.
Thank you, Judge. My understanding is Mr. Watley would like to set this matter for preliminary examination.
Discovery is complete.
To my knowledge, Your Honor.
People have their witnesses available the 21st. All right. Preliminary examination will be set July 21st, 2026.
I'm good.
9 a.m. before Judge Moore.
Judge Moore.
Bond will continue. Thank you.
Yes, and help us.
Oh, we'll find out.
I said,
Did you?
yeah. Watch it.
Court calls the case of the People versus Hunter Hallis.
Assistant Public Defender Zach Vinny Withen on behalf of Mr. Hallis, who approaches. You state your name for the court.
Hunter Hallis.
Your Honor, Mr. Hallis,
Have long pants.
Mr. Hallis apologizes for his appearance in court today. I did forget to warn him to not wear shorts. That's my fault. Your Honor, we're requesting an
Did it
adjournment.
on purpose.
No, I promise.
He promises, Your Honor. Your Honor, we're seeking an adjournment. We're waiting on some video from the people.
And if I give him the adjournment, he'll be properly attired when he comes back.
He will, Your Honor. I'll make sure of it.
How much time did you need? 2 weeks?
That's fine, Your Honor. I got the video and it's being processed, being sent over.
So beautiful.
Probable cause conference will be adjourned July 23rd, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
Woke up this morning and I said, of all my shorts, let me get the first one. No. Court calls the case. People versus Benlia Winter.
Ready again, Judge.
What are you going to say?
On behalf of Miss Winter, who is approaching. Miss Winter, when you arrive, please state your name for the record.
Leah Winter.
Thank you, Judge. She spoke with my intern at the jail the other day. My understanding is we're still working on trying to reach a resolution. If we can have a brief adjournment, we'll continue to get this matter resolved.
July 23rd, 2026, 9 a.m. Bond continued. Thank you.
I'll send Muhammad back to control. She wants me to ask for a bond, Judge.
Okay.
Would you mind if I do that? Thank you, Judge.
I don't think you want me to answer that, but go ahead.
Well, thank you for allowing me anyway.
Yeah.
In speaking to my client, it sounds like she has indicated that she will return to court should the court allow her an opportunity for a bond, not resources financially to be able to post the current bond. He's asking the court might consider a PR bond or a 10% bond, at which point I hope she could post that and she would return for all future court dates.
I've got nobody tomorrow. I was under the impression he gave me a PR already 2 weeks ago.
Judge Simpson did?
Yes. Then you.
What?
She says she's under the impression you may have already given her a PR bond on this file 2 weeks ago. Is that what your file reflects?
Okay. You say a couple of weeks ago that I gave you a.
The last time I seen you, told me to show up to court and you did offer me a personal recognizance. I got my hose taken care of and I've been in custody.
Slow down.
Sorry.
You're going too fast. Say it again.
I said, it's in the file.
Going too fast for him.
Sorry.
Go ahead.
I said that, last time I seen you, you offered me a personal recognizance, had my hose be taken care of. They did. Nobody expects me in person tomorrow. And, we've been under the impression that I had a PR.
She was moving too fast for me, Judge. What I think I heard her say is that 2 weeks ago, you told her that if she got all her holds and other counties cleared, then the court would entertain the possibility of a PR bond.
That sounds like something I would say. I don't.
That's all those holds are now cleared.
Some cash or surety
Currently.
Thank you.
All right, but okay, so in the interim, she's gotten her holds cleared up.
Correct, Your Honor. She says she does have a court date tomorrow in Novi, and she is supposed to be there in person. So she requested the court allow her a release.
Got it. Do the people see that? Or?
I'm double checking actually right now, Your Honor. I think part of the concern was there was a missed court date and the defendant indicated she was in South Dakota at the time of one for BCC. So there was a bit of a concern about flight risk, but
She said she was in South Dakota to me.
Yes.
I would have remembered that.
Yes,
I just said to Magistrate Hotel, Your Honor.
Oh.
You have an address to say with
I don't know why what was it? What's in South Dakota?
my mother. She just had surgery on this.
Oh, okay.
But I'm not leaving. I have a place to live in Adrian with my uncle, her youngest brother, Joseph Hunt.
I see 2 holds out of the next jail. One Novi and one MSP.
And
so the MSP appears to be in traffic and Novi looks like drug paraphernalia. I don't know if they would get her or not, but I still see 2 active holds. They may be cleared. Just what's the next jail?
But right, correct. That's because she says she has a hearing in Novi, so it sounds like that one was cleared. They're
And then
gonna
it's
have
not coming
to walk in, right?
That's correct, Judge. The Novi is cleared.
And then you got an MSP one that's probably, you think it's probably a traffic.
Yes, she says they've indicated they will not come get her.
They will
Then
not.
there's a $1,000, 10% bond here on the misdemeanor case before Judge Washington. It looks like
turns to PR if I get a PR here. So
that's all I see next year.
She says Judge Washington has indicated that that bond will turn to a PR bond if she gets a PR bond here. So we just have to notify her that this court has allowed her.
It sounds like Judge Washington to leave it up to me.
Well, I don't know, Judge.
Just saying.
Maybe she deferred to you on this one. She wouldn't have any objection to a tether if necessary to help address the people's concern.
Yes.
Reed. What is Akin really saying now?
That's good. Pull it up, just walking his notes on the 14 video.
Oh, she knows how to do that? Okay, go ahead. What does it say? Did she put the notes in? Or
Notes says Ashley motion. So.
it's from Ashley?
Yes.
Okay, go ahead.
This is client here, for pretrial custody, bond reduced to 1,010% to convert to PR if released out of this file.
I have court August 3rd too.
Yeah.
And then by tomorrow.
During the 8th grade to see results.
So sorry, according to the law, did grant $25,000.
I think I did. I thought as we were talking that I already did, but
perfect.
So
we don't need anything.
So Fisher has been they're wasting my time.
I took ICR, but they never got it.
They're wasting my time, and then Akin really joined in, wasting my time. I could have been done with the whole docket by now. I thought I had given her that.
I owe you 5 minutes, Judge. I'm sorry.
Got a bad dispo.
I mean, I weeks of my time.
I know. It's all time I don't get back. All right. I don't know any.
It was the 23rd.
23rd.
Yes. Thank you, Judge.
You're welcome.
So what do I tell ITR? Because I've been telling them.
What do I tell ITR? Have no clue. We will make sure.
Okay, thank God, because I missed my mom's surgery and
Okay, hold on.
okay.
We'll make sure that a proper dispo gets down indicating that your bond here is a PR. I think that the only thing that may need to follow is that Judge Washington's bond, that somebody.
I'll reach out.
Lets them know.
Yes, Judge.
Thank you.
You're welcome.
Yeah.
Okay.
Thank you.
No problem.
Okay, thank you.
Take care.
That's the most Feaster talked in like a long time.
I try to be quick.
No, you try to be quick. And then Akin really stepped in and we were going to be here all day. So she doesn't know. She doesn't know where she's going. Excuse us. She doesn't know where she's going to go in line. Oh, because then we get you. She's hungry too. She's hungry too. And the mom's watching, so everybody will know. Huh? Oh. Yeah, there are people. Court does call the case People versus Robin Hart.
I should know that. Oh, yeah.
Whoa, yeah. Sorry to wake you.
I'm so late.
That was not the case. You're Stephanie in on behalf of Ms. Hardy, but Your Honor, not with Ms. Hardy. And that is before we go too far. Hold on. Your Honor, the court did not grant my request for a stipulated adjournment in this matter. I was not in office for 2 days and she was trying to reach me. And so when I spoke with her yesterday, the prosecutor and I did
So this is my fault?
No, 100% mine for taking time off. And just it's my fault, but she literally had to choose between losing her job or court, Your Honor. I'm just asking for a 1 week adjournment. She has somebody covering her shift next week. She will be here. She's been here for every other court appearance. Please, Your Honor. You might remember she came out the building because she was in the building and it was like it was static, and so she came outside and she got reprimanded when she went back inside, and they were like, if you do this again, you're gonna lose your job. Okay. Please, it's just
It's totally my fault.
Adjourn the matter to 16,
Thank you, Your Honor.
2026, 9 a.m.
Thank you. And you're supposed to be on my side. No. And you're supposed to be on my side.
What?
Oh, yes.
Bond continued.
Thank you. The only reason that.
Hold on a second. I can only do so much. Everybody's in my ear. Here. Yes.
Yesterday.
No, it doesn't matter. It doesn't matter. It's proper.
Or I might need a kidney.
How's the case versus Dean Hodder? So
Assistant Public Defender Zach Venue on behalf of Mr. Hodder, who could be present via Zoom.
it's right there. Everybody knows Mr. Hodder because there's shorts in here. Did you not tell any of your clients about proper dress etiquette?
Your Honor, Mr. Hodder and I did not have a time to speak before the
That's a no.
so then no, I did not.
Yeah, so I'm here.
Mr. Hodder is here in court today. Your Honor, we would be seeking an adjournment for negotiations.
What? During the matter to August 6, 2026, 9 a.m. Give him time to get Pam. Bond can.
And you're gonna be like, oh, we did not here and you forgot.
I did. No.
Thank you, Your Honor.
Thank you. You're welcome. Oh. It's in the finger. Oh. She. Oh, fuck. This one over here. I need a taser. Court does call the case. People versus Tyree Hayes.
Stephanie Cannon on behalf of me. Hey, Miss Mercedes.
I can't unmute it. You were unmuted. Could you state your, oh, now you're not. Could you state your name, Ms. Hayes?
Ms. Hayes, can you state your name? She muted again.
Okay, good job. Now state your name.
Trying to unmute it. My phone is being crazy. Can you hear me?
You're fine. Yeah, we can hear you now. Go ahead and say your name.
Tara Hayes.
Your Honor, we're asking that this be set for a preliminary exam.
Discovery is complete.
To the best of my knowledge.
Do other witnesses available the 21st?
We'll try for that day.
Preliminary examination will be set July 21st, 2026, 9 a.m. before Judge Barr. Thank you. Thank you, Ms. Hayes.
Thank you, Your Honor.
You're welcome.
Court calls case People versus George Henderson.
Alexander on behalf of people here.
And good morning, Your Honor, Assistant Public Defender. Really on behalf of Anderson, who is approaching. Mr. Henderson, come on up, Sean. Say your name for the record, please.
Judge, we respectfully request that this matter be set for preliminary examination.
You have all discovery?
Yes, Judge, to our knowledge.
Do other witnesses available the 21st? Preliminary examination, July 21st, 2026, 9 a.m. before Judge Moore.
Okay, thank you, Judge.
Thank you.
Okay.
Court calls the case People versus Marcus Hopkins.
Judge. First Assistant Public Defender Torshell Feaster on behalf of Mr. Hopkins, who is approaching the podium. Please state your name for the record, sir.
Marcus Hopkins. Thank you.
Thank you, Judge. Mr. Hopkins, and I just established contact. for a brief adjournment so that we can have more discussions about this matter and determine next steps.
Probable cause conference will be adjourned to 23rd. Well,
That's great, Judge.
July 23rd, 2026, 9 a.m. Bound to continue. Thank you.
Good to handle.
Court calls the case, People versus Curtis Jackson.
Your Honor, Raymond spoke to the people.
Sleepy Share on behalf of Curtis Jackson, who is on Zoom. I did see him on Zoom earlier. Back at. Mr. Jackson, if you could turn your camera on and say your full name for the record. Oh, he's not on there?
Not on here.
Oh, Your Honor, I'd request.
Was he on here? I'll pass it. Tell him find some stable Wi-Fi. I'll call it later.
Thank you, Your Honor.
Court calls the case, People versus Eric Jackson.
Thank you, Your Honor. Alex Warren Green on behalf of Mr. Jackson.
Get out of the way. Thank you.
Your Honor, I'm asking the court to adjourn this matter. We're working on mitigation, and after we complete that, we're going to approach the people and ask for a resolution.
How much time are you going to need to try to get that done?
Could the court accommodate a 3-week adjournment?
For you? No.
With the court.
August. I'll adjourn it out to August 6, 2026, 9 a.m.
Thank you, Your Honor.
You're welcome. Court calls the case, People versus Tucker Jackson. Are we done with in custody?
And the Assistant Public Defendant, not to carry out really, Your Honor, on behalf of Ms. Jennifer Jackson, state your name for the record.
Thank you.
What is your property? Sheet.
Yeah. What
Third.
price?
Sheet today. Yep.
Oh, that's right.
Yeah.
It is. Like a blind squirrel finding a nut.
Asking for an adjournment, Your Honor. We do have the media in question. My office just had a difficult time uploading it, so I have not been able to review it yet, but she promises that it'll be done today for us to review.
So it's uploaded, you're gonna be able to, and then you'll be able to look at it.
Yes.
All right. Probable cause conference will be adjourned July 23rd, 2026, 9 a.m.
Okay.
Good. Court calls the case of the People versus Jerry Jackson. Right, boy.
Jerry Jackson. Judge, I'm asking for an adjournment. I'd like to take one more crack at the people to try to see if we can resolve this case at this stage. So for another probable cause conference date.
July 23rd, 2026, 9 a.m. Bond continues.
Perfect.
Doesn't want to go to the detective. Nothing. That's it. The whole thing. It's just that comment was not directed at you, Mr. Bull. The person that they know.
Fair enough. Thanks, Judge. All right, we'll be in touch. Thank you, Your Honor.
Well, oh, hold on a minute. Just do it. She's got to pick. Where'd you know what? Court calls case, People versus Roderick Jacob.
And is that on behalf of people, Your Honor?
This is the Public Defender Zach Vinny with it on behalf of Mr. Jacobs, who approaches.
Roderick Jacobs, thank you.
And Your Honor, we're seeking adjournment for the negotiations.
July 23rd, 2026, 9 a.m.
Thank you, Your Honor.
You gotta make a decision. Court calls the case, People versus Darius Jones.
Assistant Public Defender, not here. I can move Your Honor on behalf of Mr. Darius Jones. Mr. Jones, when you reach the podium, state your name for the record.
Darius Jones. Thank you.
Your Honor, we're asking for an adjournment. We're still in negotiations with the people in regards to this matter. We'd also like to address bond.
We'll adjourn it. How much time did you?
Ashley, what did you say? 2 weeks. Oh, 2 weeks. Yep. Thank you, Judge.
July 23rd, 2026, 9 a.m.
Bond, Judge.
Hmm?
Can we address bond? I'm sorry.
You want to address bond?
Yes, please, Judge.
He's out.
I know.
Should go south fast. Go ahead.
Judge, Mr. Jones is currently on a home confinement tether. He is asking that the court remove the tether. Mr. Jones has an injury to his hand that he suffered last year. They had to put a stent in his left arm. He has a number of doctor's appointments. He's had to move a few of them to Zoom because it was just difficult to navigate the appointment with the tech and requesting the time off. Some of them he does have to go in person. They're doing a lot of stuff on his hand because according to his mom.
I will prepare an order. I'll allow him to attend medical treatment while he's on the tether.
Okay, just the out time. He is wanting to look for work too. He's 19 years old. He states that I can add that in the order as well if the court would like.
Yeah, well, but then the home confinement, he'll just say he's out looking for work. Most applications are online, so I'm not sure why he would have to be out.
And I guess primarily we were just trying to see if it was possible to at least just make it a GPS tether rather than the home confinement.
Response from the people?
We closed, at the time of the arraignment, the public defender to present the PR bond because of the age of the CCH and the conviction father, driving mom's contact information in the West subordinate place. However, we expressed our concerns given the facts and circumstances of the case. In this matter, Your Honor, in our bond information form, we include lots of information about the defendant and the people that he was with at the time he was arrested. Specifically as to this defendant's behavior, not looking at everyone else, but it's relevant to consider when the defendant made contact with Deputy Nito, he was disorderly in the backseat of the patrol car. He attempted to kick out the back window. He began attempting to kick out the back window of the patrol car by kicking, refused multiple orders to stop. He said he was trying to damage the window, attempting to put his foot away to prevent the back door from shutting. After being advised, he was instructed in investigations. Behavior did not change and continued to demand for the police to let his brother go. So I'm very concerned about this ability to remain long time. I do think the home confinement time is appropriate in this circumstance.
I will only sign an order allowing him to attend medical treatment that's verified. So he'll have to show that he has an appointment that he needs to go to. I'll sign that order. I'm not going to allow any other fluctuation.
Okay. Thank you, Judge.
Thank you.
Thanks.
Court calls case People versus Joe.
The Assistant Public Defender Xavier with on behalf of Ms. Jones via Zoom. Ms. Jones, state your name for the record. Here.
Can you hear me?
No, we say your name again.
Olivia Jones.
All right, what's that?
Your Honor, we're seeking an adjournment for the negotiation.
July 23rd, 2026, 9 a.m. bond condition.
Thank you, Your Honor.
Thank you. Court calls case People versus Matthew McWain.
That is on behalf of the people, Your Honor.
Anybody make a decision?
Yes.
Thank you.
Stephanie Canna on behalf of Mr. McWain. Please state your name for the record.
Matthew McLean.
If you must, yeah. Court does call the people, case of the people versus none. Um. Where is she? Please, thank you. Your name?
Good afternoon, Your Honor. I am Makaina.
Thank you. People have put their appearance on the record, or you may go ahead.
Yes, okay. Good afternoon, Your Honor. Robin McCoy on behalf of Mr. Mackay Nunn, who stands to my right, P63057.
All right. This is your motion regarding bond.
Yes. Okay. Yes. So just so the court is aware, I know when I was last here, I did not have the discovery. I did receive the discovery, the paper discovery. I reviewed all of the paper discovery. I would note that there is reference to a video, which my understanding from Madam Prosecutor is that they're working on getting video. As I said in my motion, Mr. Nunn, and I've known him actually all of his life. His mother worked in our office for about 10 years. His father is here. He has two sisters here, a girlfriend, and I think it's a cousin that's here. He is gainfully employed, and he has an apartment. He has no prior record, no juvenile record, nothing of the sort. As I reviewed the discovery, and I did see there are some discrepancies, and there's some things that we obviously need to look at. We are asking that.
You mean discrepancies?
Well, discrepancies, I did see what the prosecution wrote in their response. The fact that when I was reviewing the report, it said that he was not under arrest and he was questioned, and he says he was never Mirandized. And then I did see that the officer said that he, based on what he alleged is Mr. Nunn's behavior and the evidence from the video, which we don't have here today, which they referenced some things happening on a video, that they went and got a search warrant. And so then that would lead me to believe, again, I don't have the video, that there might be some issues with the search warrant, and that all that was found was the fruit of the poisonous tree. If it's an invalid questioning, he's not Mirandized.
Okay, but what bearing does that have on his bond?
Well, I would say this. They reference certain things in the police report as a means to refute the bond. And I was not at the arraignment. I understand that the bond was set at $100,000. As I said, he has no prior record. In this situation, we're asking for a PR bond. If the court, because of the nature of these allegations, if you want to have a tether, we would say we'd have a tether, let him go to work, go to grocery store, go to doctor's appointments. I did talk to Reverend Green, and he said that he would work with him and talk with some of the other. I talked to Pastor Harold Wimberly, who works with the youth, who also said that he would work with him.
But as I review the police report, I would say this too. This is not a situation. I'm not going to name the names that are in there, but they basically are talking about other people that are involved with certain activity and pictures of other people that are not him involved with activity it's not him being involved with that activity. This is a friend. One of them is a friend that he grew up with.
Okay. But I still got an answer to my question. You're saying there are internal discrepancies with?
Well, in the discovery, it says that he was questioned about, I'm talking to him, it first says that he ran when the police came. He says that when the police came, he said he had worked a full day at his job, and we can get documentation to substantiate that, and that he came out to his car to get his charger, and then he was questioned by the police about where he lived, and that he says he told the police where he lived, and that he was not dishonest about where he lived. And they're also alleging that he said something about not going to the hospital. He did say that he went to the hospital to visit one of his friends from school who had been involved with the shooting, and that there was. So then the police were questioning him, and they were asking about searching his apartment, and then there was obviously some things that were found in his apartment. He said that he believes that somebody was let into his apartment and did certain things that he was not aware of, and that there's allegations that the items that were found in the apartment were involved with other offenses, which again, he has nothing to do with, has no knowledge of any of that.
I don't know for purposes of bond if it's something we need to get into, but who has access to his apartment?
So there in the police report, it says that he's the only one.
No, who are you saying has access to his apartment?
On the lease at the time, it's him and his girlfriend that are residing in the apartment. So it's the way the report is written is he's the only one that lives there. But at the time, it was himself and his girlfriend that lived at that. Not the current girlfriend, but a girlfriend.
I mean, am I to take then from your argument that as to what was located in the apartment, certainly during this process, you can challenge it, but he's saying that wasn't his.
Correct.
And that it belonged to somebody else who would have access to the apartment, which would mean it belonged to the girlfriend.
Not the girlfriend, but he believes that the girlfriend allowed somebody else to access the apartment, and that the other person who was involved with, what's referenced in the report is that there was some kind of shooting, and his friend Sarah calls him up and says, "Hey, I was involved in a shooting," and she was at the hospital. He said he went to visit her at the hospital. She was pregnant at the time. He says that she had baby clothes in her car, and she wanted him to take the baby clothes. He took the baby clothes, and then he went to his apartment. And then he said she was still upset, and that she comes over there to meet him at the apartment, and he's trying to calm her down, and she's upset about the situation. But he believes that his girlfriend let her boyfriend in, and that it's the boyfriend's items that were found in the apartment, not his.
And it was who?
The boyfriend, Sierra's boyfriend.
All right. Anything else?
Again, I would just say I've known him all his life. I've never known anything like this. He did graduate from Ypsilanti High School. He's had a pretty solid work history. He worked before. I know he worked at the Noodles Company. I would often see him there. He does not have a criminal background, and his family is here. His father is here, his mother, she's working right now. Everybody is very obviously distraught. He's never had anything like this. He's upset about this because he's like, this is not me. He has assured me that this is an experience. He will not associate with the people he associated with before. He said this is one and done. I know the court and, neither of us are necessarily spring chickens. We hear stuff all the time, but
I'm a spring chicken.
you're,
No, I don't know about you, Mr. Boy. You can comment on your own age, not my.
I would just ask for him, and he said he's willing to take a lie detector test as well. So I'll just put that out there.
All right, response from the people.
Your Honor, the people are concerned because this matter does tangentially involve a shooting. The defendant lied several times to the police officers during their interviews. Even the story today that's been represented by counsel is an additional new story. He first said that he went by the hospital, did not stop his car, did not get out, did not find who he was looking for and left. Then when he was pushed back by the officer who mentioned surveillance footage, he said he stopped for a minute, looked around, still didn't see her, and then left. Now today he's telling a story where he did stop, he did find the vehicle, he did find who he was looking for. He was moving stuff back and forth between the vehicle that was involved in the shooting. Yeah, this is just a deeply serious matter where I have no faith that we're being told the truth.
And Your Honor, if I may respond again, I wasn't there. The prosecutor wasn't there. This police report was written up. This is my second time talking with my client about the situation. There has been, from my standpoint, consistency where he was saying that his friend called him in distress and he was trying to help comfort his friend who was pregnant at the time and has now had a baby. And there has been consistency there. He said that at the time he was questioned, he had worked a full day, he was tired. He said that he had no intentions of being dishonest with the police. He had no idea what was in his apartment. And he said that he has had some bad experience in the past with the police. So he did obviously, I think a lot of folks have PTSD, anxiety when it comes to the police. So, but what we have is we often get reports. A lot of times I get what's in the report, and then I talk to my client. The client will say, even when they give written statements and they sign off on it, they say, that's not what I said. That's why I typically tell clients, don't say anything. Don't say anything. Tell me the truth, but don't say anything to the police talk to me, tell your mama the truth, and then just zip it when you're dealing with the police and don't lie.
You would acknowledge that were he tied to what was found in the apartment, that makes him a danger to the community.
I would acknowledge that, yes.
And so I've got to then go on some limb to find that he's not a danger to the community because it's found in his apartment.
Well, if Your Honor,
if I can just finish, please.
Okay.
I don't have anything else that points to those items belonging to someone else.
Well, in the report, though, it does say that the items belong to Devon, to someone else. It doesn't say that the items belong to him.
I know.
It just says the items are found in his apartment.
But they're involved in a crime or crimes. And they are now in the defendant's possession.
In the defendant and his girlfriend's apartment. Correct.
But how does that help me, Ms. McCoy?
If
I have two people in an apartment, then are you saying that it's the girlfriend? I mean,
what we're not saying it's the girlfriend. We're saying what we believe is that the girlfriend let this other person in there, and the other person put his stuff there. Put from the shooting.
Do I have anything that says that? I mean, other than the statement today Is there anything or any statement given that that scenario occurred?
I would say that we would need to talk to the girlfriend to see what her statement would be and also talk to Sierra about what happened at the hospital. So, but I would say, again, Your Honor, I understand you. That's why we're saying if you put him on a tether, then we will know where he is. He's got to go to work.
It isn't the question of necessarily knowing where he is, although that becomes an issue. It becomes an issue of an assessment of this individual's threat to the community. That's what it becomes. And if the scenario that you have forth can give then one assessment to those items being in that apartment. But if the defendant is tied in or hiding those items in that apartment, that's a very different scenario.
Correct.
A very different analysis for the court as to what the court should do. But the part that would favor you would be if there's some indication that someone else let them in, that being his girlfriend, and that there's this other party that put these items in to his, and I say his possession because it's his apartment too, but puts it into his possession, then that becomes something very different. But I don't have that. I hear what you're saying, but I don't have that.
Right.
You acknowledge that if those items are tied to him, that he would be a danger to the public.
I would not say again, I wasn't there. I would say if
McCoy, you could try to sidestep it all you want.
No, Your Honor, I just want to make sure I'm clarifying for the record. If he was involved, if he's lying and if he was involved, what the complaint, the 123 pages of the discovery clearly, repeatedly say is that there are other individuals out there that are a danger to society. And the allegation against him is that he lied about what happened, lied about his apartment, lied about what happened at the hospital, and that there were items found in his apartment connected to what the other individuals did. And there's pictures and it's littered with indications about these other individuals. So what I would just say is that the presumption is that you're innocent till proven guilty. Although a lot of times in our society, you're as if you're
not going to try to give me that lecture.
Guilty till innocent.
I've been doing this way too long.
Right.
Don't try to give me that lecture.
Okay.
I just need to try to talk. I want to talk about his particular interactions.
Okay.
If all of these things had occurred as they were, and an individual, how should I say, participates in a cover-up of those crimes.
Right.
Would you consider that person then to be a danger?
I would consider it definitely would be a problem. They're young, they're dumb. They shouldn't be, if they're an eagle, they shouldn't be hanging with the chickens because the chickens will bring you down. I would say that. He's 21, no prior record.
I hear that, but I also I understand. I'm sitting up there looking at this young man, and I realize he doesn't have a record. I realize all of those things. I also realize there's some very dangerous and tragic things that have occurred, and he has in his possession, whether jointly or by himself, the instrumentalities of those of that help commit those acts.
I understand. Yes.
That's the problem.
Right.
And if he has them in his possession and participates in the cover-up of that, it really becomes an assessment of how dangerous then is this individual. Because you can be stupid and dumb and still dangerous.
Well, you can be young and dumb and make a mistake and go to jail, and then you're like, I don't like this. I'm not going to do it anymore.
Dangerous.
Well, I would say he's 21. The adult brain doesn't fully mature till the age of 26. Some people would say 30s for some folks. He has a job. He has an apartment. He said to me, all he does is go to work. He did get caught up with the situation. Even
Mr. McCoy, where would he stay if I were to release him?
if you were to release him, he could go back to his apartment, or if the court is saying, no, you're not going back there, he could stay with his parents, and they live in Ypsilanti, which I can give the court the address. I just don't want to put it on the record because of, I would rather just give the prosecutor and court that privately. He has a sister that's in college in Detroit. He has another sister that lives in Columbus, Ohio.
So where would he,
His mom, I talked to his mom. She said that he could stay with her and his father at their residence.
Yes.
And now we've reached the moment where Judge Simpson has had enough. The Nicole Henderson case, tension is palpable. He ordered a mental health assessment specifically to make an informed bond decision. He's trying to help this woman, do it safely, and instead of addressing the actual issues in the report, we're getting a debate about blood alcohol levels and field sobriety tests. That's when Judge Simpson drops the hammer. Why do you think I asked for the assessment, counsel? And then the attorney goes, Your Honor, that is extremely unfair. You can almost hear his patience snap.
Good afternoon, Your Honor. Nicole Sadi. I represent Miss Henderson, and she is now at the podium to my right.
Okay.
Nicole Henderson.
All right. I've received the assessment. Have the parties had an opportunity to
People have your one.
I have.
Go ahead. Any additional argument?
I'm sorry, I didn't hear the last few.
Any additional argument regarding her release?
Yes, would you like me to go first?
Sure, it doesn't matter.
Okay. So Your Honor, I see that Miss Henderson was extremely forthcoming with Mr. Statman during this assessment. While I'm looking at Statman's recommendation, these recommendations Statman are making include abstinence as well as outpatient treatment. I'm also looking at the law enforcement bond information form that I'm showing Mr. Cook right now. Thank you. Let the record reflect, I showed it to him. Looks as though the police, the day that she was arrested, considering everything that they saw on the scene, was recommending a personal recognizance bond along with the scram tether. My client is willing to wear the tether as she understands this is normally a usual part of bond on a matter like this, as well as engage in AA. I understand that upon reading this report, it may put to somebody's mind, well, Ms. Henderson has been to rehab before. And in terms of the actual nature of addiction and rehab, Your Honor, I would argue that that is what we see when people are breaking a habit. There is a recommendation in here that is something she has not done before. Ms. Henderson has not attended Alcoholics Anonymous before and had that type of support and ability to make some sober connections. She has never done that before. And it looks as if Mr. Statman believes professional assessment that she would be a good candidate to go ahead and receive outpatient treatment combined with these other recommendations.
You're having just two brief things. One, just to slight correction from what was just indicated about the information form. Where I believe the council looking, that was the people's original recommendation at the time of charging, something we pulled out, not the police. Certainly that was the charging EPA's recommendation in the case, and when the case was first brought before this court, I asked for more than a PR bond for the reasons I indicated on the record. I know that doesn't factor into the court's decision today, but I just wanted to correct that. The second matter that, or the second piece that I wanted to discuss was in my review of the defendant's version of events as told to Mr. Statman, that they differ from what I believe the report and the evidence shows, not too dramatically, but in ways that I think it's important for the court to be aware of. Specifically, one part in the first paragraph indicates that the defendant completed field sobriety. She was only able to complete one of the 3 tests, to my understanding. The other 2 were not conducted or completed due to the defendant's lack of cooperation at that point. Admittedly, as the court's aware, she was incredibly intoxicated, so I'll just attribute that to her recollection. The event might not be the best. I don't think there was any malice on her part, but I think it's important for the court to have that corrected understanding.
I would like to respond. I will say that this is a paraphrase, and I would also like to say that Henderson.
Can I ask why you're going down the path that you're going down?
Yes, that he's paraphrasing that Mr.
Why are you
paraphrasing?
Why does go ahead?
Okay, there may be an inconsistency here, but that doesn't mean there's an intention to be inconsistent, is why I'm going down this road. I think you understand. I don't go further. The other thing I did want to address for this court's attention is while Miss Henderson acknowledges what the blood draw was, this blood draw was taken well over 4 hours after the initial arrest where blood alcohol rises. So it is not an indication of where her level was at the time of arrest.
So we're going to argue over those points?
Your Honor, in the bond argument we're making based on this report, I'm bringing forward based on science for my client to pursue.
Why do you think I asked for the assessment, counsel? Really? Why do you think I asked for the assessment?
Well, Your Honor, my job's to advocate for her.
And it'd be good if you did that, but why do you think I asked for the assessment?
I can only go by what you said. I'm not in your mind, but you said that you were concerned about my client's health. You're concerned about my client's mental health. You're concerned about her relationship with substances. And I believe you ordered the assessment because you wanted to be informed on those concerns before considering reducing bond. That's my belief.
Why can't I get arguments that go toward that?
This, in my opinion, this does go towards that. When we're looking at a blood draw this high, the science shows, and that.
You know what? I mean, I'll let you go. I'm going to do what I want to do because I've been trying to get Miss Henderson out. I've been trying to do it in a safe way. I've been trying to do it with as many safeguards as I possibly can get. Trying not to miss anything. That's what I'm trying to do. I don't know that the arguments you're giving me help me any way in that.
Your Honor, respectfully,
that means I'm going to get none. So go ahead.
Your Honor, that is extremely unfair. And on the record last time, you said something that was unfair as well.
You know what? This ain't about you.
That's right.
This isn't about you.
It's
right. Not about you.
That is correct.
Stop right now. Deputy, take her back into lockup. Court's going to stand in brief recess. All right. Yeah. Maybe see you.
Court does call the case of the People versus Calhoun.
And finally, the most complex, emotionally layered case of the entire docket. Jules Calhoun. The judge just found him competent, major development. But the real drama is about his bond conditions. He's been on home confinement for 6 months, compliant the entire time, and wants to return to his home on Duncan Street. The problem? It's about 150 feet from an elementary school. Prosecution worries about safety. They've even got a teacher and parent on record opposing his return. But Judge Simpson shows his depth. He knows this defendant has autism. He knows isolation is affecting his mental health. He's balancing community safety against individual rights with nuance. He allows the return temporarily, strict conditions, exit only through the front door, turn away from the school, GPS active, and a review hearing in August.
Good afternoon, Your Honor. Ashley, one of the closest to the people. Morning or good afternoon, Your Honor. It's definitely not morning anymore. Sunita Dasmani on behalf of Mr. Calhoun. Would you like to take the podium, Judge?
No, actually, we can hear you wherever you're coming.
Okay, thank you.
All right.
Your Honor, we have several issues to address today. First, I the court is would be, I think, the competency. That's okay.
Yes.
The judge may just indicate Mr. Calhoun is on live stream for the record.
Yes. And Mr. Calhoun, can you state your name for the record, please?
Jules Calhoun.
Thank you. All right.
Your Honor, the people are in receipt of an independent evaluation as to defendant's competency, the pines and competency in trial, which would stipulate to that. I think the defense filed a motion for reconsideration as to the competency findings. So the court is going to reconsider its finding and the original date and make a new finding. We would have no objections there.
Anything?
Thank you, Your Honor. We would agree to stipulate to that report and ask the court to find him competent going forward.
All right. I think the technical way to do this is the defendant's motion for reconsideration of the competency evaluation or competency finding the defendant incompetent. The court will grant that motion. I have reviewed the independent competency report, find it persuasive. Counsel has waived a hearing with testimony on that case, and both parties have stipulated to that report. Therefore, the court would then find that the defendant is competent to stand trial.
Thank you.
All right. Counsel, I would need you to make sure to prepare a competency order for me.
I'm sorry, Judge.
Prepare a competency order
Absolutely.
and submit it to the court for my signature.
Get that done, Judge.
And if also, I guess as part of that, I need an order that your motion to reconsider is granted.
Got it, Judge.
So those two things.
Thank you, Your Honor.
Next.
Your Honor, the court did give us a chambers conference earlier today, and we had a very productive conversation as to the issue of bond. When we were here last week, we discussed the defendant going for walks and the people's stipulation to the same, the defendant going for walks, and we were sort of discussed some of the ways to solve that. The court, the people, and defense were contemplating no go-to zones, places the defendant would not be allowed to go. It's my understanding, and I'll let defense counsel speak for herself in just a moment, that that's just not practicable for community corrections. So instead, defense counsel and I were exchanging emails about locations he could go, and I'll let her make her record for that.
No, that's right, Your Honor. When I spoke to the supervisor, tether agent, he indicated that it would be very difficult to have every single school and daycare excluded. But however, we could try to narrow it down by having specified and designated places where my client could go and exercise. They have access to a car, so they can drive to locations like the R, like the Botanical Gardens, Judge. And that's what we're trying to do now. And I understand from our conference that the court, that we outlined the different kinds of tethers, and I'll let the court make that decision, but that would be very helpful, Judge. And of course, keeping the gym as the option in the previous order, and I can draft a new order based on the court's ruling.
Anything else?
There were 7 locations that defense counsel and I discussed via email. I'll start with the ones that people have no opposition to.
All right.
Which will be the Botanical Gardens,
Trinkley Marsh at Easton Farms Preserve off of Dancer Road, Nichols Arboretum, the Ingalls Mall location near Burton Tower and the Michigan League, and the Broadway Bridge near the Huron River. There were 2 locations that were requested by defendant that people are not agreeing to and would object to. The first would be the Ben & Jerry's ice cream store on State Street and the Natural History Museum at the University of Michigan. The concern of the people with those 2 locations, especially the Natural History Museum, the presence of children during the summer months, especially doing school trips and also during the school year doing sort of field trips, and the large amount of children that can be at those locations. So we would not agree to those 2 locations, but would stipulate to the remaining 5 that we've indicated.
And one of the questions the court had prior to hearing counsel is, and my understanding is that the alleged activity, were they specifically directed at children?
No, Your Honor. The note specifically said people. It did not say children, but the concern of the people remains that the defendant was engaged in in the underlying case at an elementary school, which of course is a location that does contain a large number of children. So that is the concern of the people with those 2 locations specifically.
Understood. All right. Yes. Anyway.
Nothing to add, Your Honor.
All right. What I will do is the locations that the people don't object to, I certainly will allow those locations. I would agree with the people regarding the museum and will not allow that. The difficulty, not because I like Ben & Jerry's ice cream, but the difficulty for the Ben & Jerry's ice cream is certainly there may be kids there, but I don't see it as that type of gathering place, particularly down on campus. That you're right that the Natural History Museum might entail, but at least for the time being, I'm not going to allow that particular location. Okay, so the ones that the people agree to, I will allow.
Thank you, Your Honor. The next,
just so that we're clear, it's still a home confinement tether with the ability to go to those locations.
Okay, thank you, Your Honor. I wanted to raise another issue, Judge, that is related to his bond conditions.
Yes.
I wanted to move that this court allow him to return to his home address on Duncan Street. School is now out of session, Your Honor, and I understand the proximity to the elementary school. And I understand that, but he has been for the past 6 months in compliance with all of the court's conditions. He has been confined and unable to even go out, and he has had a very difficult time with that, Your Honor, and still has complied with all of the court's conditions. I am asking this court to consider him moving back home. Thank you.
Yeah, for the record, the people are opposed to that change in bond. The people do believe that it is not an appropriate change at this time. We would ask that the court does not allow the defendant to return home. I know the court's aware, but for the record, there was a prior incident in October of 2025 involving the defendant and a teacher at the school being on the school property while children, I understand, were playing outside, involving a potential threat. That did not result in any charges. But then we do have this extra incident that happens that does result in charges in January of 2026, where the defendant was remaining at his house at that time. He had lived in the house for both of those incidences, and we are opposed to any change in bond. I've had the opportunity this afternoon in court to speak with a teacher who works at Hazley Elementary School, and she's assured me that she feels confident in speaking for the teachers at that location, and they would also oppose any change in bond to allow him to go back to the home, as well as I've had the opportunity to speak with a parent of a Hazley Elementary School child, and she's informed me that she feels confident that she could speak for the parents, and the parents of these children would also oppose the change to allow him to go back home. I understand that there are concerns about, and I know school is out right now, and so I want to share with the court what I understand the concerns to be, that there's concerns with feeling safe sending children to the school by the parents, given the nature of the threats, concerns that the children would not be safe if he was at his home because of the proximity, should he choose to leave, if the police response couldn't be done in a sufficient amount of time, because he's so very, very close. And I understand the concern from the teachers, a similar concern. Also, the teacher that I spoke with expressed to me a concern she had about her ability and the children's ability to remain focused on their schoolwork and to remain focused on what they're doing due to the